Have some breaking news, so I'm going to thank you, Kevin Ankush. If you could stay around, we were just telling you that we were waiting for the verdict in this landmark case involving Meta and Google, accusing them of designing features that are addictive for users. Lisa Rubin is with us as well. The first and key question was Meta negligent in the design or operation of Instagram? The answer, Lisa,
is yes. And Chris, the jury has gone on to a couple more of these questions. Number two is actually next to number one, the most important question here. The question was Meta's negligence a substantial factor in causing harm to KGM? She is the plaintiff in this test case in Los Angeles who says that using Instagram and YouTube caused her all sorts of mental health harms. The answer there was yes. And the reason that that matters is even if Meta or YouTube had been negligent with respect to her, if that negligence wasn't a substantial factor in causing harm, then you don't award any damages. This means for sure we will go on to the damages phase of the jury reading their verdict. But so far, every answer to the jury's questions, or I'm sorry, rather the questions on the verdict form have been yes. Did Meta know or should it have reasonably known that the design or operation of Instagram was dangerous or likely to be dangerous when used by a minor in a reasonably foreseeable manner? Yes. Did Meta know or should it have reasonably known that users would not realize the danger? Yes. Did Meta fail to adequately warn of the danger? Yes. And would a reasonable platform designer or operator under the same or similar circumstances have warned of the danger? Yes. And then finally, with respect to Meta, was Meta's failure to adequately warn or instruct a substantial factor in causing the harm to KGM? Yes. These two theories of both negligence and failure to warn being the two routes by which KGM could have held Meta liable here. We're also seeing that the verdict is being filled out by the jury with respect to YouTube. And there, similarly, questions 1 and 2 so far, the answers have been yes, which means that we will hear from this jury in Los Angeles as to how they assess damages against Meta as the owner of Instagram, Google as the owner of YouTube, with respect to this particular plaintiff. And I want to just note for you and our viewers, this is what's called a bellwether trial. It is the first of many trials that are expected to happen in Los Angeles Superior Court where people have alleged that their use of social media has been a harm to their mental health as minors. A bellwether trial generally gives people an indication of what these trials would be like if they are all tried. One might expect that depending on what the sum is at the end of this verdict, you may see a lot more settlements than you do trials by the end of this.
Again, I just want to point out, Ankush, if I can, that in the questions of were YouTube and Meta negligent, was it a substantial factor in causing harm to the person who filed here? And should they reasonably have known that the design or operation was dangerous or likely to be dangerous when it was used by a minor? Yes. Talk about what you see as the significance here, Ankush.
Oh, look, I could not improve upon what Lisa said in terms of the significance of this verdict. Of course, we're going to want to know what the number is. But look, there's another element of this that is quite significant as well. Because for years, these platforms had managed to sort of push off these types of lawsuits based on Section 230 immunity under the law. These lawyers who have been bringing these cases have developed a novel theory, which are novel theories, which are really more rooted in consumer protection and tort violations, meaning, you didn't set up the platform correctly enough, you didn't abide by your duty of care. So to see these cases moving forward, now there'll be appeals, presumably, but to see them going forward in this way is a very positive signal. Lawyers. It's a bad sign for these companies, of course, because no matter what the dollar amount is, it's going to be very important to the plaintiffs.
I'm going to interrupt you for a second because we've just gotten the dollar amount, if you want to report on that, Lisa.
Yeah, and the jury has assessed her damages overall. We still don't know how they're going to distribute them between Google as the owner of YouTube and Meta as the owner of Instagram, but $3 million. And right now, I would say we see that Meta is 70% responsible. YouTube is 30% responsible for this award. Now, $3 million might not strike us as a lot, particularly given that yesterday in the state of New Mexico, the attorney general there won a trial against Meta where $400 million was awarded in damages, $375 million of that Meta's responsibility. But that was a lawsuit on behalf of lots of people, the state of New Mexico and its minors, and whether or not Meta was responsible for child sexual exploitation. Here, we're talking about a single plaintiff and a jury finding that Meta and YouTube are responsible to her to the amount of $3 million in terms of the damages to her mental health as a minor from using both of these platforms. When you extrapolate from that, if that's what it's worth with respect to her, you've got to imagine that the general counsels of both of these companies right now are really rethinking their strategies with respect to trying these cases. The other point that Ankush made is about Section 230. There has been some congressional opposition to revamping that federal law, which for the most part has insulated social media companies as well as all sorts of internet service providers from liability based on what happens on their platforms. This was a workaround. This was a strategy to show that you could sort of circumvent Section 230 by holding the platform owners responsible for negligence, that they had a duty to people who were using the platform to design it in a way that minors couldn't circumvent, for example, the sort of restrictions on use. Given this, you may also see some members of Congress come forward to say, you know what, we should take another look at Section 230 liability and where we are and are not immunizing social media platforms, internet service providers, computer companies writ large, because for dozens and dozens of years, they have largely been not accountable to what happens to people online. So, for example, if somebody posts a tweet online, Twitter can say, well, that's not our responsibility. We're just providing the platform. There's a lot of mechanisms for social media platforms to sort of disassociate themselves from what is said on their platforms. This is proof that that immunity is not going to last forever or for all purposes.
So, Ankush, we just got the final part of this as we're looking through the verdict form. And the question both about Meta and YouTube was this. Did you find that KGM proved by clear and convincing evidence that YouTube, Meta, acted with malice, oppression, or fraud in conduct upon which you base your finding of liability? And the answer is yes for both of them. Yes, in the case, as I read it, for YouTube, and yes, in the case of Meta acting with malice, oppression, and fraud in conduct. What does that mean for cases going forward? And also the conversations that will be had, I'm sure, late into the night and early into the morning by the lawyers who represent these two huge social media companies.
Yeah, well, so look, this is a repudiation of this company. It's just one case, but I can pretty much guarantee you that the lawyers for these companies are going to be doing the math as we speak on what the $3 million might do if you applied it to pending cases and potentially prospective cases that they may have already flagged. I will also, one of the things that Felisa flagged is also important. I mean, that what has been going on Capitol Hill with respect to Section 230 immunity has been, there's been forward movement on this. So I actually think I think politicians in Congress will be paying quite close attention to this. Last year, a bipartisan group of six, I don't know if it was six, but a sizable bipartisan group of senators released a bill to sunset Section 230 immunity in 2 years. Now, it hasn't gotten very far, but this is the kind of news development that if you're these companies, you should be worried about when there's pending legislation like that.
Many of us remember, Lisa, that among the people who took the stand in this case was Mark Zuckerberg.
Yes.
I imagine there's some uncomfortable, potentially, conversations going on there. Well, what do you imagine those might be?
Well, this is an illustration of the perils for CEOs of taking the stand at any kind of trial. We saw a trial verdict in a case involving Elon Musk and shareholders of Twitter who were upset about certain representations that were made when that company was being purchased by Elon Musk. He, too, took the witness stand at a trial. The jury came back, I believe, the day after he completed testifying. Oftentimes, lawyers will say to CEOs and founders, it is not a good idea for you to take the stand. And oftentimes, when a case has gotten this far without settling, those folks will ignore that advice. That advice is good advice. They should listen to that. Oftentimes, founders and CEOs are not in touch with how their products are perceived by the general public. They're not in touch with how their image is understood by the general public. And in this particular instance, Mr. Zuckerberg's appearance in court, he was seen as being arrogant and maybe even belligerent on the stand. I imagine that when people like our own Gillian Frankel, who has been covering this case day in and day out, gets to speak to jurors, that one of the things they may tell her is that they were really put off by the corporate representatives who took the stand, including but not limited to Mr. Zuckerberg.